Hello everyone and welcome back to the channel. I've been following the Gun-Free School Zone Act case out of Montana for a few videos now, and today we have a big update. The case is going to federal court. For those of you not familiar with the story, I encourage you to watch the previous two videos. The Sparks Note version is Gabriel Metcalf lives across the street from a school. He and his mother have restraining orders against a former neighbor who is allegedly so crazy that the police even have special orders not to confront the guy in person. He has attacked and threatened to kill the Metcalf family on multiple occasions. He has also been allegedly violating the restraining order, and so Metcalf began carrying a single-shot shotgun while in his yard. Parents with kiddos at the school across the street called the cops. The cops said they couldn't do anything because he wasn't doing anything illegal, and then the feds showed up and arrested him for having a gun in a school zone. Then they kept him in jail for a month, came up with a 3-year-old warrant that was pretty fishy, and finally released him on condition of GPS monitoring, which he has to pay for. The guy threatening him, by the way, is under no such monitoring despite a rap sheet a mile long. Metcalf's record is otherwise clean. But before I get into the new details, today's video is brought to you by Blackout Coffee Company. Blackout Coffee has their holiday roasts out now. Everything is roasted fresh to order, and proceeds from their partner roasts go to some of your favorite gun rights groups like GOA and Firearms Policy Coalition. To check them out and help support the channel, go to blackoutcoffee.com/libertydoll. Metcalf and his mother can barely keep the lights on, and so Metcalf was awarded a federal public defender, Russell A. Hart, who, surprisingly, seems to be doing a really good job. Not gonna lie, did not see that coming. Hart filed a motion to dismiss the case as Montana law exempts Metcalf from the Gun-Free Zone Act unless he is in an actual school building. He filed the brief to dismiss on October 10th. The feds took 2 weeks and responded on the 24th and argued that Montana law doesn't apply in the Montana case, and neither somehow does the Second Amendment. So now it goes to federal court. The case seems pretty cut and dry. From Harts Brief, Montana has 1. Verified that any individual who is not prohibited under the laws of Montana or who has not been convicted of a violent felony crime is qualified to receive a license to carry a firearm within a school zone. 2. Enacted legislation granting such a license to all verified individuals. 3. Explicitly stated that this license applies for purposes of the Federal Gun-Free School Zones Act. And 4, enacted separate legislation that goes farther than 922Q could under its Commerce Clause authority, prohibiting the possession of any type of weapon, including a firearm, but only within the school building itself. If Mr. Metcalf stepped from his property onto the public sidewalks while carrying a firearm, as the government alleges, he was licensed to do so by the state of Montana at the time. The prohibition of 922Q2A does not apply to him, and the indictment must be dismissed. And a quick note on the public sidewalks thing. The only reason that he allegedly left his property with the firearm is because the police told him that he needed video and photographic evidence of his former neighbor violating the restraining order. According to Metcalf, the guy had been driving by and casing his house for weeks. And so he went outside to get some pictures and some video, as per police instruction. But the assistant U.S. attorney argues the Montana law that Metcalf relies upon, Montana Code Annotated 45-8-360, includes express qualifications for a person to be considered to be individually licensed for purposes of the exceptions to the Gun-Free School Zones Act, excluding individuals 1. Convicted of a violent felony crime, or 2. Otherwise not able to own or to possess a firearm under the Montana Constitution. The statute, however, does not require that law enforcement authorities of the state verify that the individual meets those qualifications before obtaining a license. Wait, what? That can't really be their argument. Their argument is really that the cops will give out licenses to someone with a violent felony conviction or who is a prohibited person. That's not how the system works. Anyways, because the Montana provision does not meet the federal requirements for the exemption to apply, Metcalf's firearm possession was not exempted. Okay. Hart also argues that Heller and Bruin are on Metcalf's side. When it comes to firearms carried for purposes of self-defense outside the home, 922Q contains an identical ban to the one flatly struck down in Heller when applied to firearms stored inside the home. In Bruin, the court ruled that regulations concerning firearms carried outside the home must be held to the Heller standard while unequivocally rejecting the application of any means and scrutiny to justify the regulation. The ban prohibiting possession of a functional firearm within 1,000 feet of a school's grounds in 922Q2A prevents a citizen from using it for self-defense if confrontation happens outside their home. On its face, 922Q is impossible to square with the Second Amendment in the post-means and scrutiny era of Heller and Bruin. But the feds say that Heller and Bruin are moot points because the Second Amendment itself doesn't even apply to the case. His claim under the Second Amendment fails for two reasons, either of which is sufficient to deny relief. First, the Second Amendment does not protect Metcalf's course of conduct. The Supreme Court has repeatedly made clear that the government may prohibit the carrying of firearms in sensitive places, such as schools and government buildings. Right, but again, that's in the building, which is Hart's whole argument. The founding generation heavily regulated firearms on the campus of public universities, and starting in the latter half of the 19th century, some states heavily regulated firearms in and near schools. In some ways, the restrictions were narrower than Section 922Q2, but in other ways they were broader, and there was no apparent dispute about their constitutionality. Further, under Bruin, a modern-day restriction need not be a dead ringer for historical precursors. It need only be relevantly similar to the precursors in how and why it burdens the right to armed self-defense. Section 922Q2 passes that test. So let's address those claims for a minute. The only possible historical analog was 18th century laws banning students from having guns within private universities. Keywords there being within the private universities and students. The only 19th century law that could be relevant banned people from shooting their guns near schools. Contrary to this attorney's argument, the Gun-Free School Zone Act itself was once ruled unconstitutional and as a result went under a minor cosmetic change. Metcalf's state case is also being addressed by a public defender, one who Metcalf's mother has described as uninterested and downright hostile. The family, and folks like myself who have been watching the case, are, admittedly, a little suspicious of this 3-year-old charge that suddenly cropped up and no one claims to have known about it before, and it has the potential to be dismissed if Metcalf is properly represented. If you'd like to help Metcalf, his mother set up a Give Send Go for his defense fund that I will link down in the description. That's it for this one, guys. I will keep bringing you updates as they come. I'm definitely interested in how this case plays out, as Hart has some pretty compelling arguments, and also we just learned that the county is going to be building a school across the street from our house. So, Montana, but still possibly very relevant. South Carolina is very free with their Second Amendment rights, but I know a lot of people who have said that about Montana too. We live in a pretty rural area where it's common for people to shoot off their back porch, shoot to scare coyotes away from their cattle and chickens, hunt on their own private property, or just have fun with a home plinking range. I can't imagine that the state would ever come down and say, you can't do that because they decided to build a school across the street, but this is the feds saying that state law doesn't apply. So I will definitely be watching this one closely. In the meantime, you know all the algorithm funsies that help out the video and help the channel, and as always, thanks for tuning in, and happy shooting.